Welcome to Human Recursos. Just Ask Jacob or Just Ask Jacobo, podcast where immigration and employment law meets real-world business challenges. I am your host, Jacob Monty from Monty and Ramirez. In each episode, I will sit down with leaders from across the industry to tackle big questions that keeps business owners up at night, from workplace compliance to immigration reform to everything in between. My guests bring questions, and I bring over 30 years of experience helping employers navigate these issues. If you're a decision maker navigating today's labor and immigration landscape, you're in the right place. Workplace advisors, you're helping employers navigate compliance, avoid litigation, avoid missteps. How long have you been doing this?
Well, I personally have been doing it more years than I really want to admit to. I've been doing it my whole career. The Workplace Advisors we started 15 years ago, and it used to have a different name, Affinity HR Group. We rebranded it a couple of years ago because HR is just one of the things that we do. We do a lot of other workplace challenges, but most of what we do, most of who we serve are businesses that whoever's doing HR may not be an HR person. It could be the owner, it could be the finance, the CFO, it could be your office manager, somebody who's wearing many hats. And so we really are there to answer their questions and provide support to them. Over the years, we've grown to include recruiting, employee development, compensation. So pretty much the whole kitchen sink. We don't do payroll, we don't do benefits, we don't do safety and OSHA, but everything else, we're really here to help support our member clients. And we partner with associations within specific industries. So we really gain a deep knowledge within those specific industries, the sort of the special nuances of some of the workplace challenges that exist within those industries.
And boy, talk about breadth. I know you help some white collar industries, but also some heavily blue collar industries.
Yes. Exactly. Well, and the reason being, and this is a great opportunity for us to talk, is that employment law is employment law. So while there are some nuances by industry, or if there's a collective bargaining agreement that might change that, by and large, the laws apply regardless of whether it's white collar, blue collar, exempt or non-exempt. And so we're really here just to provide those resources and to help businesses and to meet them where they are. You know, there is no business that is 100% compliant. I think it's impossible to do that, right? I mean, it's a big challenge. You've got state, you've got federal, you've got local laws in multiple states, but we really just try to help them be as safe for their workers, have a safe and healthy work environment for their workers, and also maintain compliance with the law.
Well, when you said, you assist people that are in the HR role that may not have been SHRM certified or trained in HR, that really resonated with me because a lot of my clients, they have professional HR people with degrees and everything, but some of them don't. And some of them are large companies that promoted from within, and you might have an accountant in that role, you might have an administrative assistant in that role. As you said, it might be the owner in that role. And it's important for them to have some heavy duty backup. And I have spoken with many of your advisors, and they do have, just years of experience. They're HR professionals that back up the companies in the field of HR. So I think it's an excellent model. Let me ask you this. Have you faced situations where a client just said, well, we've been, I-9s, we don't, what's that? And where you have to tell them, hey, there's a requirement for you to have an I-9, or you can't pay people like that. If you're paying like that, you have to pay overtime, and where they completely did not know about the law, and you had to kind of bring them into compliance.
All the time. Like all the time, because there is so much complexity, and a lot of employers just don't want to deal with it, or they had a special craft, a special calling that led them into business in the first place. And some of them are small and some of them have become very, very big. We have a client who is a billion-dollar company with a B. They have no HR. And that's not by mistake. You don't end up to be a billion-dollar company with thousands and thousands of employees and no HR. That's usually a philosophy. Like, I don't want to do it. I don't want to be hamstrung. I don't want to be told what I can do with my workers. And I mean, I get that, right? Who doesn't, who wants to have those constraints? And so what we really try to do is just meet them where they are. Like, all right, that makes sense. This is illegal. What you're doing, how you're classifying these employees, how you're paying these employees, how you're giving them, I don't know, comp time instead of overtime, or
You can't do that anymore. I mean, I just heard, I saw a blog where you could. I mean, I've had that conversation with clients for 25 years and they're just like, well, the employee wants it. Well,
yeah, they prefer it. So they're
Yeah.
not going to. And I think that's actually the really interesting piece, is that they're like, look, my employees have been with me forever and they're not going to want this change, or they don't want us to play by this rule. They want to be exempt. They want to be classified as exempt and not have overtime because they want that flexibility, which is great. Unless you have one person who says, I should have been getting overtime these last 3 years. And then, then you're in trouble. So we really just try to counsel. We're not the principal. We're not the police. We are advisors. So we're here to try and help inform them on how to be as compliant as possible and to conform to the law as much as possible. And some of them take our advice and some of them are like, right, thanks for your input. We're going to keep doing this really, really illegal thing. So,
Well, one of the things I admire about your pricing and is that you have entry points that are accessible for very small companies and of course larger companies. But oftentimes, I think that is the reason people may be out of compliance, because they can't afford $5,000 a month for an HR consultant or $70,000 a year for a good HR person. So, you offer them, different price points where they can get some compliance, some advice. And I think that is very important because price is the factor.
I'm going to bring you back to my office because we are looking at reevaluating our pricing, because we are priced as affordably as we possibly can be, because we know, especially the smaller businesses, they don't have a budget, right? And they need help when they need help, but they don't have an ongoing budget. They don't have an allocation for this. But some of the bigger companies that do, they see our pricing and they think, I need way more than that. Whatever that is, that's not sufficient. And so sometimes you need to just jack up the price in order for there to be a perceived value. So we walk that dance constantly. I kind of wish somebody could come in and say, this is how you should price this, because this is going to be more meaningful. If it's
Well, Claudia, I did, by the way, not only am I a fan, I'm also, we're in the process of signing up as a client, because I think we filled everything out online and we're just waiting for confirmation. But I copied, you in that regard recently. I just made a proposal to a big restaurant chain, and they have essentially franchisees, and
Yes.
we gave them an immigration compliance package that my partners were like, is this crazy, Eddie? Jake, you are pricing this way, basically
Insane. Yeah.
10% of what a typical matter costs,
Yeah.
and maybe a little less than 10%. But I think that, I didn't go into it blindly. I know what their payroll information looks like. I know what their I-9s look like. and we've been representing a few of them already. So it was, we did it, and we're getting lots of them to sign up. But they, for lawyers, we love the hourly, the billable hour, because, it's idiot proof for the lawyer. I mean, just whatever it takes. But companies hate the billable hour, and
Absolutely.
there's no budget. It's you can't really anticipate, and so lawyers love the hourly billing model, but companies do not like it, and they're looking for a flat fee. They're looking for predictability. They're looking to meet budgets, and I just commend you for doing that. And it's weird. I got I can't say, but it's a big entity. Y'all would know it, but it's funny. They did ask me, well, what's the pricing going to be like next year? And I said, guys, I may not be in business next year. You guys may have bankrupted me, but we are doing that because we believe in compliance, and we also believe in offering them a flat fee for this particular aspect of immigration compliance.
I recommend that, and there's one surprising benefit to it, and that is that a lot of folks, when they face something that it really is precarious, right? It is. From a risk mitigation standpoint, they really do need to be getting that advice. But if they know when they pick up the phone and call that the clock is ticking, and somebody's going to be looking at that bill and saying, "Why did you call Jacob?" or "Why did you call Claudia?" then they're less likely to do it, and that's when they make mistakes. That's when you have those challenges. So we find that a lot of businesses, they just like the reassurance to know that we're here, right? So it's an insurance policy for them, and we've got folks who use us all the time, but didn't when we were on a per hour basis. So it's the first year is the scariest. It's all I can say. But we found that by and large, we have just the sweet spot. It's folks who need us. We're here. And then they know that they've got us if they need us, but otherwise they're good to go, and they know that they have an affordable project. And we also do their employee handbooks, their policies, their procedures. We give them regular updates. We're constantly providing information just so that they know that there's somebody keeping an eye on them, and that there's somebody keeping track of the landscape that they are operating in, especially on a multi-state basis. I mean, everybody says, "Oh, well, Congress isn't doing anything." Well, they're not doing very much. That's true. And this is a Republican, quote unquote, business friendly administration. So we don't have to worry about any of that. Well, the states are moving on by themselves in massive fashion, even regardless of political party. These states are taking up the mantle to regulate businesses on an ongoing basis. And so now businesses have to keep track of all of that. So yeah, our work here is not done.
Well, I got to give a shout out to Paige.
Paige, yes.
Look, I'm a nationally recognized expert on the I-9.
Yes.
Claudia, my wife, keeps me humble. She says, "Jake, great, congratulations. You're a subject matter expert on a one-page form, hurrah." But I want to say Paige is somebody who knows the I-9, dare I say, as good as me, or hell, maybe better than me. We chat about I-9 issues, esoteric points on the I-9, but she does know it and takes it very seriously. And when I'm stumped, that's who I call. So,
thank you for that. And I know that the return is absolutely mutual. I know that we've been trying to help our businesses, and with all of this I-9 stuff, the business obligations haven't really changed, right? They've had to fill out these I-9s since the 80s, and those obligations haven't changed. But the enforcement and the evaluation of them has changed, and people who may have had legal protected status, work status, that status has changed. And so having you as a resource for our clients has been invaluable because, as it's a federal issue. So we don't have to find an attorney that's licensed in every little corner of the United States where we have clients. And so having that relationship, I think, has been great for us, and it's been we're grateful for you. We're glad to have you on our panel of experts that we call to. You're our phone a friend, so I'm glad for that.
Claudia, before we leave the I-9, I just wanted to cover this scenario, and I was surprised it's come up so much in the restaurant industry. But the scenario is, hey, we're missing I-9s for a year, and I'm like, yeah, maybe for that 1 year, the person who was doing it was on maternity leave or out. And you have some companies, big and small, that are missing 10 I-9s, 100 I-9s, 600 I-9s.
A box of I-9s. We had a box of I-9s go missing. Yeah.
Yeah. And the problem with an I-9 is if it's gone or missing, replacing it is tricky because you can replace it, but it's going to be late.
Yes.
But I always say a late I-9 is better than no I-9. But
and that's the situations where we call you, Monty. What do we do, Jacob? What do we do? How do we help? How do we resolve this situation? Because by and large, employers are trying to do the right thing, and a lot of the fines and a lot of the penalties around I-9s are entirely clerical. They signed or they didn't sign. They checked or they didn't check. They dated or they didn't date, and that's by and large what they get caught up in. And so, yeah, when they go missing, that's heart attack time. That's calling you.
The last couple of weeks, we've been dealing with another issue, which is a number of employers. And this is where I think the government, just has made bad policy. They have published a Spanish I-9. Great. But the Spanish I-9 is valid only in Puerto Rico. And it's causing some employers, some issues because, they don't tell you that on the form that, but they should. Valid only in Puerto Rico. But you have a number of employers that have used the Spanish I-9 that are now having to make corrective action to get it. But as I say, the I-9 is a law that has been around since '86. Great for lawyers, bad for employers. But thanks to workplace advisors, you can keep them in compliance. So we've talked about 86. Let's transition to sexual harassment. Sexual harassment became illegal in 1989. That's the
before it was fine.
Yeah, it was a perk, right, of management. Or we say that joking, but certainly it was not a joke for the victims, and certainly some companies operated in a fashion that encouraged it or certainly didn't penalize it in any way.
Absolutely.
Are you surprised that we still see harassment complaints in 2025? I mean, shouldn't we have got this already? Nestle's CEO just resigned or was asked to resign because he had a relationship with a direct report. And
then there's the whole Coldplay incident where the CEO and the head of HR. Yeah, I would love to have hope that by 2025 we would be done with this. But in reality, the issue about sexual harassment, it's usually not about attraction. It's usually not about having feelings and love or even lust. A lot of times it's about power. It's about exerting power. It's about controlling and authority. And sometimes it's about lust. And quite frankly, most people find their significant spouses, their significant others at the workplace. Like if you want to find a good place to go and meet your next life partner, work is a pretty likely place to find them. So it doesn't surprise me that we're still dealing with this. What I find so sad is that I don't know that we've made a lot of progress.
Yeah.
I still have situations where we work a lot in the janitorial section, and it's segment, and there'll be a day porter or a cleaning crew who gets assaulted by one of their employees or gets assaulted by one of their clients. And what do they do about that? It's one of those situations about workplace safety that I find heartbreaking. And increasingly, this is a terrible trend, but increasingly we're seeing challenges that transgender people are having in the workplace. It's a form of bullying that is showing up as sexual harassment, and we're having a lot more of that to deal with. Now, sexual orientation is a protected status in some locations, but it's really just trying to figure out how do we advise our clients to maintain the policies that protect all of their employees, regardless of whether it's allowed or not allowed on the federal level. They can establish those policies themselves within their workplaces. And that's a good line of defense if something should ever happen, that there's that they don't believe that anybody should be subjected to harassment for any reason.
In terms of investigations, you would help the employer do the investigation, counsel them so that they do it properly, and they follow what the courts have held is the reasonable standard for an employer once it's been reported, once a sexual harassment claim has been reported.
Yes, we guide them. We always think it's best that the employer do that investigation internally if they can. Now, sometimes the parties involved, it's at such a level that the employer is not an unbiased arbiter of the situation, and they'll hire us to come in and do that investigation. But that is the kind of guidance that we present. What is appropriate? What is allowable? What is not allowable? How to conduct a safe investigation? From the get-go, what does that even look like? So most of what we do, we rarely get involved in the actual investigations because we really want to train our employers, our clients, and teach them how to do it effectively and safely. Because also, if an employer does that themselves and is committed to doing it themselves, that helps reinforce culture. That shows that they take these things seriously and they don't just sort of wash their hands of it, that they're creating a level of accountability throughout the organization.
Absolutely. But you said it yourself. Sometimes the relationship is so frayed, or maybe the decision makers are so biased that
or a party to the situation. I mean, we've had that where the decision makers are actually the perpetrators, the alleged perpetrators of the situation, that they can't sit in judgment of themselves or of their number two, who was their best man at their wedding. These things.
Well, that's great that you do offer that service. I mean, it would be a separate service, an added extra, but that you do offer that service. And that's where I think Zoom and Teams has made, in the olden days, you or I would have to, get on a plane and do this, usually, and that added a lot of cost.
Yes.
I'm sure now, with
virtually, we did almost everything virtually. I mean, Paige, who you talked about, she's been with us for well over, 10, 12 years. She's phenomenal. We've only met in person maybe a half a dozen times, maybe a dozen times. I don't think it's even been.
She's in North Carolina, right?
She's in North Carolina. We're all. I'm in New York. She's in North Carolina. My recruiting team is in Virginia. My compensation is in Arizona. Like, everybody's everywhere. Georgia, Ohio, all over the place.
Great. Let's talk about recruiting. Are we experiencing a labor shortage? Yes or no?
Yes.
We are. Okay.
Absolutely. We absolutely are. I have a party trick. So, as you know, Jacob, we both are public speakers. So we follow each other around at different events. One of my party tricks is, how many of you have had a hard time hiring people? And they all raise their hand. How many of you have open positions? They all raise their hand. How many of you were planning on laying off any employees? No one raises their hands. And the reality of it is, we have had a labor shortage for a long time. The current unemployment rate is about 4.2%, and it bumps around 4.1, 4.2, 4.0. That's been considered full employment since 2019, other than the blip during COVID. And if you look at our birth rates, if you look at the baby boomers that are retiring, and we look at the size of the cohort in Gen Z that's coming in, we look at our immigration, which, as everybody knows, is definitely on decline. We don't have enough workers to fill the jobs that we have today. And we are going to have fewer and fewer workers going forward. So those businesses that want to grow, if they need people to grow, they're going to have to be very, very intentional about that workforce challenge. It is the oh my gosh moment that I try to instill every time I speak. If you knew you were going to lose your product, or if you knew you were going to use an ingredient that you use in your production, if you knew that your funding was going to dry up, if you knew these critical crisis points were going to happen within your business, you would have all hands on deck saying, how are we going to address this? What are we going to do about this? How are we going to come up with a solution? And yet people don't think, they don't see labor the same way. You know, when are they going to come back? When are they going to get off their sofas? When are they going to get back and work the way they were working before? They're back. Everybody who wants a job has a job. Everybody who can work is working. So,
Claudia, what are some of the strategies you've seen, some of the, the good employers, the successful employers employ to recruit better, and to tackle this labor shortage?
so it's two sides of a coin. First is the recruiting, and then there's the retention. So on the recruiting side, being as innovative as they can and telling the story, using their employees and their current workforce as an ambassador, looking at not just compensation, but really looking at what employees want. And we know they want adequate compensation, but not necessarily top dollars. They want flexibility. They want to know that there is a career path, that somebody's thinking about them. They want an organization whose values match their own, that is not only doing well, but they're doing good, and that there is a commitment to wellness and well-being. And these have been the things that employees have said they've wanted for year upon year upon year. Really, since COVID, that's been their priority. So I think it's looking at your marketing materials, how you're telling your story, what vehicles you're using, if you're using TikTok or social media, how you're deploying your current workforce as ambassadors to go out and try and find those workers. I think a lot of businesses are used to the hard struggle of finding employees. I don't know that there's anybody out there who's saying, just don't know how to find employees. They typically know it's oftentimes boots on the ground. It's getting out there and telling that story. The nut that they haven't cracked yet is how to keep those employees, how to keep them engaged, how to keep them from quitting. Did you know that 1/3 of the workforce quit their jobs in 2022 during that great resignation?
Wow.
50 plus million people quit their jobs in 1 year. In 1 year, 1/3 of the workforce turned over. So that's not healthy. I mean, maybe it's healthy if you're an employee that wasn't making enough money. But the thing that I am committed to right now, this is really what my pet project is. If I had $1 to spend of my clients' money on this particular challenge, it's to fix the problem that has always been the problem, which is their absolute weakest link are their supervisors and their managers, because the age-old adage, people don't quit their jobs, they quit their supervisors and their managers, is still true. And we don't train them on how to have empathy, how to understand behavioral style, how to have emotional intelligence, how to navigate challenging conversations, how to set performance expectations, how to provide feedback, how to document challenging conversations or personnel challenges. All of these things we do not train. We do not train our supervisors and managers, and that, I think, is the lowest hanging fruit on changing culture.
Claudia, and that's also the reason employees will seek a third party like a union for representation. It most of the time is not pay and benefits that drives the employees to the union. It's the obnoxious supervisor, the supervisor who yells, who points at them, who humiliates them, and that costs money.
And they feel like they're not being heard.
Yeah.
I mean, the greatest defense against an organizing drive is to treat your employees with respect, to listen to them, to be honest about what they can and cannot do, to be honest about how you can afford or not afford certain things. Like, treat them with respect, and they're not they don't want to spend money for a union if they don't need to. They're happy just to work in a place that respects them and honors them and is a positive work environment.
Claudia, let me ask you about this debate. You know, employers are told you have to, document, performance problems. You have to, I guess, write people up if they're engaging in misconduct. But employers aren't doing that when they need to do it. Frequently, serious misconduct is not documented, or you ask the client about it and they said, well, yeah, I documented it, but in my notes. And then you ask, well, did the employee acknowledge it? And they're like, no, well, I didn't want to confront them, but I have my notes, Claudia, or, it happened on this day. And you're just kind of like, well, that's not really that helpful because, if the employee didn't acknowledge it, how is that a write-up? How is that, where's your proof that you raised it with the employee? But, I sometimes have this problem with employers. They don't want to, establish a penal environment where, you get so many demerits and, is there a fine line between writing up, using PIPs and then not running a penal colony where, so many demerits, equals your termination?
Paige and I were just talking about this. She's writing an article about this as we speak, and we had a great conversation about it. I think all of our clients are optimists because they're having the hard conversations. It's not like they're not having the hard conversations. I mean, some of them are not. Some of them are like literally they won't have any clue this employment action is coming their way because we've literally never said anything to ever about that. But a lot of times they hope. Like, we had a good conversation and I'm pretty sure that's not going to happen again. And then it happens again. And then they have another conversation. I think part of it is just this, it's the hassle factor. It's a culture. People don't want to be the hall monitor, and they don't want to have to sign in and sign out. Like they hope that they are going to get, that they're going to not have to escalate it to that level. Having the employee sign off on and we had this conversation about this. I'm just hoping they're writing it down somewhere. I mean, even if you have some that have a journal entry, at least I'll take that over having an employee sign off on it. But I think the one thing that is a surprise to a lot of our clients is that they think employment at will, right? And I can just fire them for any reason. But the proof is that they have to be able, in a court of law, they have to prove that they fired them for performance reasons and not for a discriminatory or protected status reason. So the burden of proof falls on them. So the more they have the documentation around the conversations that they already are having, for the most part, that they're already are having, is just it's like business hygiene practice. And it doesn't have to be every interaction. It doesn't have to be every conversation. Those can be notes. But once you start saying, this is a problem and we need to come up with a solution to this, once it becomes an honest disciplinary conversation, it absolutely should be documented. And it doesn't have to be that hard, and it doesn't have to, and even if the employee won't sign it, as long as somebody witnessed the conversation or knows that the conversation happened, that's satisfactory. Because otherwise, if you don't have any of that documentation, it's pretty much as if it didn't happen. And you did the hard work already. You had the hard conversation. That's the icky part. Just write it down.
No, great. So true. So true. What about last chance warnings? Have you employed them where, a last chance agreement where, maybe progressive discipline has already been employed and the employee, and the employer, agree, hey, Jose, this is your last chance. And if we get another violation of this sort, you're going to be terminated. And, that.
I'm always of the option. I'm always of the mind that policies are meant to be followed, but with discretion, that managers have discretion. And I also have these hard conversations. I had a conversation with a client just last week. They had an individual who was literally using drugs at work and had exhausted all of the disciplinary process, was still using drugs at work. And no, all of the supervisors and managers wanted to fire this employee, but the owner wouldn't do it because he was kind-hearted and because he was hoping she would turn a corner. And she didn't turn a corner. And what happened by not doing the right thing is it completely disenfranchised everybody else. Like literally you're letting somebody use drugs at work and nothing can happen to them, So why should I care? Why should I perform well? My thinking is always when you follow the policy and you're at a point where you're going to do a last chance, you're setting a precedence. So if that's the precedent you want to set, that's fine. But if you're not going to give somebody else a last chance, then you're in trouble. Then that's the inconsistency where you can find yourself in a lawsuit because you let Jose have a last chance, but you're not letting me have a last chance. Is it because I'm a woman? Is it because I'm pregnant? Is it because then it's all just a mess.
Great points. On the recruiting side, I just want to cover one thing. You have a model that is different from, I guess 25 or 30% of the yearly salary, which is seems high to me. And employers don't like paying headhunter fees. Could you talk about that? And it seems like the realtors, there was that lawsuit where all of a sudden, realtors weren't going to be set to that 6% standard. It was found to be violative of antitrust laws. But on the recruiting side, the industry really hasn't changed much, except for you all. I've seen that offer a different model that's different from a percentage of the yearly salary. Could you talk about that?
So one of the things about our entire model is that we have a number of trade associations that we're a part of, 21 and the Manhattan Chamber of Commerce. So that represents 35,000 companies. Not that they're all our clients, but we don't have a problem finding clients. We are just trying to service them as best as possible. On the headhunting side, basically what we did, and I don't think we're allowed to even use that term anymore because it does have certain overtones, but on the active sourcing and recruiting side, we looked at how much time it actually took for us to find talent. How many hours did we put in to do this? So we have a flat fee, and it's a very reasonable flat fee. We've got 3 different models depending on the size, the level of the position. And we ask for 1/3 upfront and 2/3 upon placement. And so that's considered a retained search. So you're committing to sticking with us for us to fill those positions. And we've been very successful with that. And recruiting is going to be disrupted. It has been ever since, Monster and LinkedIn and Indeed, because people can now find and source talent. Gone are the days of a recruiter having a Rolodex, right?
Yeah.
Half your listeners probably don't even know what a Rolodex is. But we're all subject. We all have access to the same databases of potential candidates that are out there. So we just try to really price our projects based on how hard it is for us to find that talent. My partner is a CEO, and he was hired through a very big national recruiting firm. And it cost his company, he's a CEO, it cost his company almost $100,000 just to place him. And they didn't do half of the things that we do. We do benchmarking, we do video interviewing, we do coaching. We bring in our compensation practice to figure out what that compensation could be. And we're making good money on these projects, but we're not, we're not trying to fill our coffers unnecessarily. We get paid for the work that we do, and we try to keep it affordable. But that was another situation. Somebody's like, your prices are too cheap. You must be filling the positions with, insufficient candidates, which is not the case. Sometimes we're just reasonably priced.
Great. Well, we are so happy to have you. I'm so happy to have you on my podcast.
So happy to be
Human Recursos, Just Ask Jacob, where I talk to leading experts about all things HR, all things recruiting, all things compliance. It's been a great pleasure to know you over the years, Claudia St. of the Workplace Advisors. And it's been nice to chat with you on, everything from I-9, sexual harassment, the great labor shortage, and how to write up or document performance issues. Great pleasure.
Well, I think as long as there are laws and as long as there are employees, you and I will be fully engaged and employed, and we will have each other to rely on. So I'm delighted by the offer to come and speak and to spend this time with you. I've enjoyed it. We love working with you. My whole team loves working with you.
Claudia, so you're not anticipating robots replacing either one of us, because they won't need HR professionals or lawyers if robots take over, right?
Yeah, you know what? I just want a robot to come and clean my house. I mean, even the robots that you can buy aren't good enough. So, I think we got a couple more years in us. I think we got a little bit more runway before we're completely obsolete. So I think we're good.
Thank you so much, Claudia. I really appreciate this.
Thank you, Jacob. It's wonderful seeing you.
Great.